A municipality is defined in the Bankruptcy Code as a political subdivision, agency, or instrumentality of a state. So basically a city, a county, a sewer system. If the state runs it and if it's within the ambit of the state, it's a municipality. A municipality would file a Chapter 9 for any reason that any other business or person would file a bankruptcy. Your revenues don't match your expenses, and there's no other way out but to use a court procedure to do that. As a result, the Bankruptcy Code makes getting into Chapter 9 much more difficult than getting into Chapter 11. First, there has to be state-enabling legislation. In other words, in only about half the states can a municipality only file Chapter 9. Second, you have to be insolvent. And that's a cash flow insolvency test. You have to be able not to be paying your bills as they become due, essentially. Third, you have to have tried to stay out of bankruptcy by negotiating with your creditors. None of those are prerequisites for filing Chapter 11. So Chapter 9 is much more difficult to get into. But in the interim, the bankruptcy court's powers are much more constrained because of the constitutional constraints of having a federal court meddling in the business of a state municipality. As a result of these federalism concerns and the states keeping tight control over the gatekeeping or access to Chapter 9, there are other options available. And oftentimes those are interim steps to Chapter 9 which could replace Chapter 9, like the emergency manager in Detroit, the receivership statute in Rhode Island, the AB 506 negotiation process in California. These are all examples of gatekeeping statutes where the state tries to steer its municipality to a fiscal solution outside of a federal court bankruptcy.